All right, so this is another one that's pretty important. Most of the states are pretty uniform in what they require here. They're not 100% uniform. But the will in almost every case must be in writing. The one exception where you might see that this actually will work, where the exception works, is if, for instance, you had someone who was in a desperate battle over in Iraq or in Syria. And right before they died, they said, look, I don't have a will, but this is what I want done before I die, and there's several people that witnessed it. There may be a slight chance that if they were all able to get back to the United States sometime and go through the probate process, that the court might accept that. Probably not, but that's the only exception that you usually find. So it's got to be in writing. It has to be signed by the testator, the person who's creating the will, and that person has to understand what they're signing. So you'll see a lot of people when their parents get really, really old, they'll try to have their parents sign a different will that has more money coming to them than their siblings and things like that. Well, if the parent doesn't really know what they're doing, then that will probably get challenged in court and probably not be accepted by the probate court. It has to be properly witnessed, and this is where a lot of wills have a problem. You have to have two competent witnesses. They both have to be present at the same time. They both have to see each other sign the will. And usually, it's much better if you have a notary there. The witnesses cannot be a beneficiary of the will, nor can they be the spouse of a beneficiary of the will. So if mom and dad try to write out their own will or get a will program or something like that, and have the kids sign as witnesses, totally invalid, in most cases. Or the alternative to that might be that the kids who witnessed it will not be able to take any property that's in their will that's given to them, but the kids who did witness it might be able to. So you can't have that conflict of interest, in other words, in the will when you witness it. It has to be in proper legal form as well. Will a written will work? Probably not. I wouldn't try it. Most courts don't like them. Yes, Link?
I was just curious, do people ever do videos?
There are video wills that are done. That, as long as there is legal precedent in a lot of ways, you'd have to have a very competent law firm to make that work, because you'd have to have witnesses to the video. There'd have to be a way for those witnesses to be connected to the video. But yes, that can be done. There are, situations where, somebody who is disabled but still capable, they may not be able to sign their will. So in that case, they can have somebody sign for them as long as they're able to say, I want this person to sign my name because I'm not capable of doing that. So there are exceptions to these rules, but yes, that does, it is possible. But if you try to take your own little, video at home, this is what I want done when I die, that there's no way it's not a legal form. It's not going to work because there's not enough ways. Just hasn't been witnessed, it hasn't been verified, all that kind of stuff. It should be a lot simpler to do that. Okay, here's the options a will can provide. Naming a guardian for your minor children. So just because someone is the guardian of your children's person doesn't necessarily mean they're going to be the guardian of their property. So if you've named someone to be the guardian of your children, then you also need to make sure that you make provisions for them to have access to any insurance proceeds or ways that you're going to have them pay for them raising your children, right? Fund that. That's very, very important. Because just because you name somebody the guardian of your children, they don't have to accept that nomination. And by the way, it is a nomination. You're nominating somebody in a will. The court, though, has the final say. And so the court will appoint somebody, but your will's going to nominate them. So if you're nominating somebody, make sure you've done it right. Make sure your will's valid. Because here's something that does happen in this situation, and we did talk about this a little bit before, but if you want a friend or friends to raise your children if something happens to you, maybe your family just is too far away, maybe they're too old, maybe they just, they don't have the same values you do. Well, you got to think about it, because that will better be ironclad, because if they take that and challenge it in court because they want to try to get the kids back in the family again, you better have the resources all set up for that to be taken care of. So you better have the insurance proceeds set up. It needs to go into some kind of a trust for the benefit of the kids. You know, there's all kinds of things like that that need to take place. But that's one where it really takes a good attorney to get involved and make sure that that's been created correctly. Giving directions to your guardians, that's one you don't see often a lot in wills, but it's an important one. Attorneys don't even think about this sometimes, but you know, what is it that you want these people, why are you having them raise your kids, right? What is it that's important to you about them? Do you want them to be able to go visit their families, you know, periodically? Do you want them to, you know, have certain, you know, values that you really want to make sure that are, you know, a part of it? Do you want to make sure that they know their family history? Or, you know, what are you trying to get the guardians to do? What is important that you want the guardians to do for them? That can be done in a will. You can name a custodian over small amounts of property. You can actually also insert a no contest clause. So let's say that you have 3 or 4 kids. You're afraid that they might fight with each other about, you know, who's getting what in the will. And you can put a clause in the will that says, if anybody contests this will, then they are disinherited automatically. So that's kind of the poison pill, right? And that's the purpose of that is to say, don't mess with this, right? This is what I want, and this is the way it's going to be. It also allows you to choose an executor. So if you don't have a will, the court's going to appoint an administrator or an executor for you. Specific or conditional bequests. So if you have a specific thing that you want somebody to have, that's going to need to be done in a will. A specific piece of property or something like that. Or if there's a conditional bequest that I want my brother to have this on, you know, under these conditions, if he agrees to these things, that can be done in a will. And of course, funeral arrangements and last comments and body disposals, how your body's going to be disposed of, whether it's going to be buried or whether you're going to cremate or whatever, that can also be in a will. Yes.
Sorry, I have so many questions.
Right.
So if, let's say you have someone that is supposed to be the godparents of your children, is there a way that you can make your will so that while the child is a minor, that they have sole possession of that money, but then once that child becomes 18 or older, they get the possession of it? Like, is there a way to make sure that your child gets that, essentially?
Yeah, in most cases, they're going to get it when they're 18, which may not be what you want to happen. You know, give $300,000 or $400,000 to an 18-year-old, that may not be the best thing to do. We actually had somebody recently who died in Las Vegas, one of my clients, and ended up by mistake that 2 of his grandchildren got $1 million each, and both of them are, I think one's 19 and one's 23. Not a good situation, right? Yes.
You want to take 10 and then finish? So
Yeah,
we can get
that
food
sounds
and then
good.
finish?
Take 10. You guys want to shut these things off for a few minutes?
Yeah. Yeah, so take 10.